ladies and gentlemen. Welcome to episode 31, part 2 of the Burress Law Life and Friends podcast. This may be the only time we've done a part 1 and part 2.
I'm flattered that I get to be a part of it.
Yes. So part 1 was sort of a behind the scenes at the personal injury claims process at Burress Law, from the moment that they call to the moment that hopefully the check is distributed and everything is good to go. This is more, to me, this part 2 is kind of set up to be, this is why you don't want to delay. This is what you don't want to do between the incident date and when you contact us, because as soon as you contact us, we're going to tell you all these things, and then we're going to tell you again, because sometimes we tell clients and then we wake up and clients have forgotten what to do. And so, but these are things that anybody needs to know, because again, 99% of people will be in one of these incidents, be it a truck wreck, car wreck, dog bite, some sort of incident. Right. And if you're not, your spouse is. And if your spouse isn't, then your child is. And if your child isn't, then your mother is. So these are the things to keep in mind. First, so understanding insurance tactics is the topic. Claims adjuster or insurance claims adjuster. I got to tell you, when I was a kid, when I was an adult but not a lawyer yet, I would hear this term, and I did not know what it was. I did not know what an adjuster meant. I didn't know what it was. Did you?
I did not. My first exposure to claims adjusters was when I became an attorney. I heard the term, but I didn't have a clue what that was.
And I'll tell you what, when I was a teenager and was hit from behind by an F-250 and was really messed up, lost a whole season of golf, and like it was a huge, I was in a little Cavalier back, you remember the Cavalier?
I had a Cavalier. I had a purple Cavalier.
Okay, well, let me tell you, when you get hit, when you're stopped by an F-250 with a big brush guard going 65, you do not come out of it very good. And I was really hurt. And I did not learn what a claims adjuster was because my family didn't have good sense to make a claim. And so I got a big fat nothing, but a bunch of medical bills and heartache and neck aches and everything else. But now we certainly know. So when we talk about understanding insurance tactics, it really starts with this insurance claims adjuster. And I'm not saying that all of them are bad people. Certainly
not at all.
Not at all. But what are they there to do?
They are there to be the representative for the insurance carrier on that claim and to get it closed for as little dollars as possible.
And that's just the fact of the matter. They're there to minimize payouts and protect the insurance company's bottom line.
Yeah. That's what insurance companies do. They take in premiums, they pay out claims. How do you make money in that scenario? You take in more than you pay out.
It's the only way to maintain a job. Now, that said, there's some that I can tell you are absolute sweethearts, and they try to do the right-ish thing. And really, that is sending claimants to Burress Law, which, by the way, that happened the other day. I absolutely love it. When one of our insurance company adjuster folks sends their loved ones to us, that is the greatest compliment we can receive. That
opposing counsel sends us clients. I love that.
Judges makes me very happy. But I digress. We're talking about the claims minimizer. The claims adjusters and what they do. And part of the way that they minimize claims is the way that they approach you. Like, they don't necessarily approach you in a standoff manner. In fact, some of them are representing the company through which you have your policy.
Right.
Be a UIM claims adjuster or a PIP claims adjuster, right?
Correct. same scenario though. It doesn't matter if it's your insurance carrier or third parties. They're trying to pay out as little as possible.
That's right. It's a subtle art of appearing really friendly to the layperson, whether it's their own insured or the responsible party's insured. And they will appear empathetic while gathering information that can weaken your case, right?
Right. Yeah, no, that's fair. They're going to come in with a smile on their face and set the traps that they can set to try to minimize payout.
They certainly have questionnaires. They certainly have outlines of questions to ask, right?
Sure. When they are asking questions, especially if it's a recorded statement, they may take a recorded statement. Why does an insurance adjuster need a recorded statement? You can't talk to someone and remember what they said? But why? Because that statement can be used against you later on down the road.
Can and will.
It will. And they're not asking you questions. They're leading you on. As attorneys, we can only ask leading questions in certain areas. Mm-hmm. What I've noticed is they love to ask the question in a way with, you would agree with me that, and then get the insured to agree.
Yeah, we would all agree. We all agree that medicine helps that pain, right? Well, yeah. Have you been taking medication for your neck injury? Well, sure am. And did you take that from the emergency room? Did they give you a prescription? Right. Yeah. And when you take the Flexeril and the hydrocodone, and then does that make your pain better? Yeah, absolutely. Hey, so on a 0 to 10 scale, how low is that pain? Not what is, but how low is that pain? How low can that pain get? Well, a 3.
See, and I would go even further. They're going to put it as, hey, that pain's as low as a 3. I mean, they're going to throw it out there.
And the insured, the victim, has in their head, you've just talked about taking medication, which definitely makes you feel better temporarily, yada, yada, yada. And then they get you to say this really low number, and all of a sudden they're going to weaponize it later to go, well, the medical records later talk about a 7 out of 10 on pain score, but I mean, 3 here, 3.
Right.
And the opposing counsel will be able to use that at trial to impeach you. The jury never even finds out that recorded statement was taken by an insurance company, because you can't use the word insurance in a trial, right? It's the craziest thing.
Yeah. That statement's problematic. And, I know we talked earlier about intakes. That's one of the things we want to flush out. Have you given recorded statements? Who have you given them to? I would also say the recorded statement has a way of disappearing in litigation if it's not useful to the insurance company.
Boy, does it. It is amazing how all these recorded statements exist when they're bad for our side, but they're never really there when it's bad for the other side. It's so strange.
Yeah. The number of discovery fights I've gotten in on, I know there's a recorded statement, get it to me.
Well, the defendant will admit to you during deposition under oath that, yeah, I absolutely gave a recorded statement. And then the lawyer for, whomever, what recorded statement?
Yeah, one of the last ones I had was we finally got a recorded statement that referenced another recorded statement. I'm like, you just said in this statement that you have a statement from something. I don't have any of them, and anyway, we're getting off
Yeah,
topic.
but that's another thing they do. The insurance adjusters use these recorded statements, and they're not using them to remember things because they could take notes on it. They're using it to box you in on your claim, and it's super dangerous. What about these lowball offers? So these insurance adjusters are making these offers. What, in your experience, do these initial offers look like?
It is.
And we're talking about when they don't have a lawyer. They're not represented. What do these offers to the victims look like?
Oh, it's ridiculously low. I mean, we had one years ago where the client was trying to handle it themselves. They had an offer of $75,000, and it comes to us, and we go through what the case is actually worth, what the value of it, and we triple 4 times that offer. That's one of the myths that I get is, well, why hire a lawyer and pay him when you could just deal with the insurance company directly? You're not going to get treated the same.
Yeah. I'll tell you one. I mean, we had a really big settlement ultimately. A hang on, this is going to take a while. Multi-million-dollar settlement. And there was a $25,000 settlement offer made. Mm-hmm. That's what they do. We've had a couple this week that came in. They're good cases. Can I tell you what they're worth? No. Can I tell you that they're very likely six-figure cases? Yes, on both. One of them was a $2,000 offer. The other one was one of these hybrids where it was a $500 offer plus up to $5,000 in medical expenses, and then they cut it off. And so in that case, there was some psychology with it. There was sort of hey, this is going to be out there, but we're not going to keep it out there.
Yeah.
Like, you need to take it now. And actually, that was what drove them to calling Burress injury law.
Right. Yeah, the lowball offer is, now there's multiple carriers and they all do it differently, but it's not uncommon to get an offer that doesn't even cover medical expenses.
Not even close.
Right.
Not even close. I think we had one with a ER bill of $56,000. There was $2,000 offered.
Yeah.
The case, I don't want to say names, but the case that we took from a dad that whose kids go to MCA. Mm-hmm. So one of his employees. So that ER bill was like $37,000. They first told him that he didn't have a claim at all. They're denying coverage, and then for whatever reason, they came back and said, "We'll offer you $2,000."
Yeah.
And that's when he was like, "Wait a minute, this story doesn't make sense." I don't know why they did that, but this story doesn't make sense. And now I'm going to try to get help, and came to us through his employer. Those lowball offers. Bottom line is, don't accept, because if you accept the lowball offer, there's a industry term for it. And these insurance companies make these initial lowball offers, and they're called swoop and settle. Swoop and settle. Swoop in and settle for nothing. If y'all have watched Landman, which I think is the greatest show on TV right now, they're doing that as well, although that's coming from the company, not an insurance company, presumably, but oil company. But don't do it, because if you sign, it's a done deal, baby. You cannot come back later and say, "Well, I don't really like the deal that I signed, just because I didn't have a lawyer." You're done.
Right.
So don't do that. Let's talk about some dirty tricks. Have you seen any dirty tricks? Like
the newest dirty trick that I'm very passionate about, I haven't run this past you, so I'm going to find a way to make some law in this area, is we will submit the medical bills on behalf of our clients as part of that demand, and the insurance company, instead of dealing with me directly, will try to go and buy those medical bills.
Yeah, what they're trying to do is, so there are damage elements in a personal injury law case, and those are medical expenses in the past and future. A lot of these can be in the future, but lost wages, and then non-economic damages like physical impairment, mental anguish, pain, loss of consortium, things like that. But there's an anchor point, if you will, to the past medical bills. And if the insurance company can negotiate all those down to, 60% down or whatever, 50% down, then they make that medical expenses damage element very small. That impacts the rest of your case, and all of the statistical data shows that. And they know that. They're not jumping in to try to pay your medical bills to help you.
No.
They are doing that to hurt your case. And it's a dastardly trick.
It is, and it's done by your own insurance carrier on PIP claims, it's across the board. It's not just third parties that are trying to do that to people.
Yeah, and we've won a number of times when it's your own carrier trying to do that on PIP. In fact, we forced them to double pay, to pay again. There are other cases where we force them to claw back that payment. So there's a number of ways to do it. It's harder when it's the responsible party's insurance company. The insurance lobbyists have managed to trounce the trial lawyers' lobbyists, and they have somehow made this where it's not a HIPAA violation for an auto insurance company to call a victim's medical providers without any HIPAA authorization and get all their medical records and medical bills and start negotiating claims on your behalf without your knowledge or even approval. Right. It's insane.
It's insane, and they've managed to set up the law where when you submit a health insurance bill on behalf of your client, the insurance company has no responsibility to handle it, but they can if they want to.
Yeah. And I think our best, the best, not really the topic here, but really it's a gift. They're making a gift. That gift, I get the victim gets no release out of the deal. The victim gets no indemnity out of the deal. And so really, there's nothing there that says this is a concluded medical bill at all.
Right.
And how many times have we seen medical providers reverse these payments, reverse these discounts? They reverse payments to health insurance carriers. They reverse all the time and then try to get more. And so I view it as a gift, but bottom line is it's pretty dastardly. So you got, what about others?
I've seen denials of coverage. I've seen...
Yeah, just plain denial of coverage.
Right.
We just had that. So we have a case. We haven't put anything on our socials yet, and we don't put client identifiers typically unless they are really giddy and want to and take a picture with us. Great.
Right.
Okay, we'll show a picture and say their first name. But anyway, on this case that we just settled a week ago, the settlement's for about $2.4 million, maybe just a hair under that.
Yeah.
And there was $1 million policy. One of the policies was $1 million policy. And all the way through mediation, they claimed no coverage under this policy. No coverage because of the vehicle that was being driven and yada, yada, yada. And it was no coverage.
Right.
They paid $900,000 of the $1 million on that policy last week.
Yeah. And, kind of piggyback on that, I see cases where they're saying, oh, here's the auto policy, and as we get towards the end or getting, trying to get a resolution, then magically the excess coverage shows up.
Yeah.
And it's like, well, we needed to put them on notice a long time ago.
Yeah. It's amazing how these things happen. Another one is all this claiming of pre-existing conditions.
Right. That's a big one. So what they're doing there is they're trying to say that, oh, you do have these injuries, but they were caused by something else other than this crash. And at times, they're grasping at straws. I have a case right now, and I know we don't say names, so I'm not going to. It's a sweet young 18-year-old girl who has suffered injuries to her spine, and she was previously involved in sports. Again, I'm being very vague on purpose. And they have paid an expert who goes, yeah, those are probably sports-related injuries. And I'm like, you haven't touched her? You haven't asked her if she was ever injured in sport? You're
Never
just going to start with that idea that, nope, it's got to be something else. So
I'll tell you what, we've got a law partner who loves pre-existing conditions. Even if there is a pre-existing condition, he loves because the law actually provides protection for those who have pre-existing conditions. And the insurance company, on behalf of their responsible party, their bad guy or bad girl, I like the bad girls, they buy those accelerations of the pre-existing
Right.
condition. If somebody was at a 4 on their low back,
Yeah.
and you take them from a 4 to an 8, you're responsible for that
right.
difference. And to me, going from a 4 to 8 is everything, right?
100%.
So Brian loves to make them pay. Bad girl, bad guy, bad insurance company, he doesn't care. I love Brian's philosophy on that.
Yeah. No, he does a great job with it. And, the law in Texas is that you take the person as you find them. So if you've accelerated that, you're responsible for it. Years ago, I had a low impact case, elderly gentleman. Remember those old great 90s Chevrolet pickup trucks with those big plush seats, and they looked super, that's what he was driving. And the adjuster was like, we wouldn't have even injured him if his back hadn't already been messed up. And I said, that's right.
Yeah.
But it was. And you don't want to mess it up. Tell your insured not to run into him.
Yeah. I had a case with a girl with, I don't know the technical term for it, but it's brittle bone disease. But same thing, like the school bus driver goes over a speed bump, and you know what? And it goes over it too fast and too hard. And you know what? You're responsible for all that. You take the plaintiff as you find her, right? And she had brittle bone disease. So what about use of medical records? How have you seen the other side use these?
That's probably the biggest defense tool that I see, is to try and recreate as thorough of a medical history of the claimant as possible, and then go back to what we just talked about. Find anything in there that you can point to go see, no, they had back problems 5 years before this crash, or just anything like that. It's
even if they got over it.
Right. It's just, they try to dig through medical record. They want to get everything. And the stories on that are, I got a mile long. I've had a defense attorney just haul off and subpoena records from every major hospital in DFW with no basis that we ever treated there. Get urology records for a person that has a broken arm. Like, there's not relevant stuff in there, but
I've even had them look at, point out records. They're like, look there, LBP, baby.
Yeah.
Low back pain. I'm like, no, that's low blood pressure, you idiot. What are you doing?
Yeah.
It's a family doctor. It's not talking about the back. We're
Right.
talking about conditions.
Right. Yeah. No, it's the number one way to defend those cases, is to try and find anything else you can hang your hat on.
Yeah. Which is why, we talked about in part A, like usually it is not a very good idea to go to your family doctor for your personal injury case. It's a bad idea. 90% of the time, your family doctor is not going to see you anyway if you've been involved in some sort of crash or other incident. But you want to stay away from those family providers, those family doctors, primary care physicians, they call them, because they don't tend to write accurate, concise medical records to prove the extent of your injuries.
No, most medical providers that aren't dealing with traumatic injuries like this day in and day out, those notes and records and charts are not written with the thought that I'm going to get this poured over by attorneys. And so it's just that's not what they're using them for. And so, yeah, that's why, going back to what you mentioned, going to your primary care physician is a bad idea.
Yeah. And I think probably the biggest tactic that we see the insurance companies using to defend the cases, it's surveillance and social media.
Yeah. Social media is the biggest change in what I do. 20 years ago, if we wanted to know something about somebody, we had to hire a private investigator. And you still see private investigators, but now you can find so much stuff on social media. Most people have gotten savvy enough with social media that it's getting harder to find stuff. But some people, especially maybe some younger clients, certainly aren't. They may not have that security up where they need to have it. And if you make a claim that you were injured in Texas, they are 100% looking at social media to try and find you.
Yeah. And we could do a whole podcast on the dangers of social media. Bottom line is our contract prohibits social media use
Right.
in its entirety. Now, are there circumstances where, you have to call a little bit of an audible? Yeah, if somebody uses social media for their business, things
Sure.
like that. But I'm telling you, you have to watch it like a hawk because, somebody can be really injured and their spouse may drive them down to the hill country
Right.
to enjoy a glass of wine. I'm telling you, those adjusters and later those attorneys are going to be holding up those pictures. Look at this. They were able to go on vacation. Look at this, drinking.
Yep.
Look at this. I mean, that to, the 70-year-old woman or 50-year-old woman just picked up a grandbaby and maybe she hurt her back because of that. It's just dangerous.
Yeah, it's and as someone who's not in this field or in this job, you don't think the way we think. So you may think this photo's so innocuous, so benign, and then it becomes the exhibit A.
The biggest thing I hear, it's almost the same, you quote it. Biggest thing I hear. Yeah, I'm on social media, but I don't put anything on there.
Right.
Yes, you do. Yes, you do.
Yeah. Yeah.
Well, but I've got stuff on there, but I got nothing that'll hurt the case.
Yeah.
Yes, you do.
Yes, you do.
Yes, you do.
So, and what I would say, as far as social media goes, it's a problem for the defense too. Because if you don't think I'm looking up their side on
That's
social
right.
media, I 100% am.
That's right. That is right. But one of the ones that I'll never forget, social media. Our client had made a post like 7 years later about breaking the arm, and this was a broken arm case, and
Right.
he used the wrong arm. And he just said left instead of right or whatever it was. And I mean, the adjuster and the lawyer could not get it through their head that this was a mistake. And so it was just a simple mistake on social media where the client said left instead of right. And it almost caused us to have to try that case. In fact, I don't remember the name of it, but I remember I think we had to do pretrial on that case before finally getting it done. Dangerous. And if it wasn't an arm, it was a leg. But it was.
Yeah,
one.
I remember
I'll tell you the
case.
name after.
Yeah.
I've got the name now.
But the one I remember the most is it actually worked in our favor. Is the defendant put stuff on social media, said some not nice things about me and about
Totally
our
unreasonable
clients.
there.
And yeah, I hadn't even met her yet, but she could say it after she met me, but before. But she doubled down in her depot and lied about it. And I had printouts of social media, and it's one of my favorite depots because she finally looked up at me and said, "Well, are you just going to keep showing that I'm lying to you?" I said, yeah. I am.
And I guess to tie it all together, kind of a longer episode, which is why we broke it up into two parts. I mean, but in fairness, our people, our millions of viewers, they have received expert analysis. I mean, in fairness.
I have been told on multiple occasions that our back and forths are just the greatest things ever.
Yeah,
So, I mean, the more Jason Kyle you get, I think it's the better.
Let's not get into how much those people were paid to say that, but but we've talked about the behind-the-scenes working of a personal injury case. Hopefully, they've enjoyed that, and then this part has been about, hey, for most of y'all, if you're not being represented initially, here's what the insurance or adjusters are doing to minimize the value of your claim and really harm you. And so, what do you need to do? First thing you need to do is call us, 214-726-0016. And while you're calling us and on the phone, you need to tell us, by the way, I have hit that triangle button on Facebook. I've deactivated my
That's right.
social media, and just do all that at the same time, and we'll give you a sucker. I don't know. We'll give you something.
Yeah,
We'll give you something.
We'll
give
figure
you,
it out.
We'll give you a bottle of wine after the case is
That's
over.
right. It's a big building. We've got treats somewhere.
All right. Well, thanks for being a part of the
Yeah,
show,
absolutely.
Kyle, and taking the time. And we hope you all have enjoyed it. This is the Burress Law Life and Friends podcast, and we'll see you soon.